have a great admiration for law, but I am not myself a lawyer, although I've done some study of that. And while corruption is quite clearly an issue for lawyers, it's a much wider issue as well in the teaching fraternity and elsewhere in management. So I wanted to start with just a couple of brief comments. As Miloš pointed out yesterday, Transparency International Canada had a significant role in the development of or not so much the development, but the passage of the Canadian Foreign Corrupt Practices Act back in the 1990s. And as Miloš also pointed out, Transparency International itself was heavily involved in the development of the international legislations, particularly the OECD Convention, which was driven in large measure, in my view. I joined the movement in 1993 and founded the Canadian chapter of Transparency International back then. And one of the things that I discovered as I got involved was how significant the corporate influence in the United States was with respect to the shaping of the agenda of Transparency International. And it had to do directly with the fact that the American corporate community, or certainly leaders in the American corporate community, felt themselves to be at a significant disadvantage internationally because they faced the rigors of the Foreign Corrupt Practices Act and others did not. So moving to an international convention was something that was being pushed very hard by Transparency International. And as I say, Canada, the Transparency International Canada played a significant role in ensuring that the Canadian government moved to pass the legislation back, I think it was 1998, but my dates might be incorrect. The convention needed one last signatory to bring it into effect, and Canada had not yet signed on, although they said they were interested. But the lack of movement in the Canadian government was so marked that it became clear that the Christmas convention or the Christmas holidays were going to take over, and the convention was not going to be signed. And so I urged my board to become involved in sponsoring that particular bill. And over a very short period of time, we were in fact able to engage and create some enthusiasm in Ottawa, largely through the Senate. One of the unique characteristics of the Canadian legislation was that it was actually introduced first in the Senate, very unusual for Canadian legislation, passed first in the Senate, and then went to the House of Commons where it was passed and became law. Interesting, too, at that point in time that the chief movers and shakers were progressive conservatives in the Senate. The leader of the Progressive Conservative Party was the one who took it on and moved it forward. And two of us were invited, Michael Davies, who some of you will know, who was the vice chair of Transparency International, and myself actually had a chance to speak in the Red Chamber, a chance which I suppose is not going to be repeated, but it was very interesting at the time to participate in that particular initiative. There's some irony to that, actually, that I wanted to mention because I think it's particularly relevant to what we're doing today. And the irony lies in the fact that while I was one of the key drivers for Transparency International, and Transparency International Canada was one of the key sponsors for that particular act, I was myself a skeptic. I was not at all persuaded that in fact the internationalization of the American legislation was going to be effective. And one of the things that I'd done as I watched the pressures building was to work with a PhD student who was working under my supervision. And we did a study of the American Foreign Corrupt Practices Act as it was working out in the 1990s. To see whether or not it actually was making a difference with respect to American companies. We did quite a wide study, but one of the case studies was, one of the elements of our study was Nigeria, where the American corporate community was heavily involved in investment in the oil and gas sector, where corruption was absolutely rampant. And to the concern of many of my colleagues in Transparency International, the conclusion we came to was that while the Foreign Corrupt Practices Act had created an enormous industry in the United States, for which lawyers were the primary benefits, that's to say working with corporations on the moves that they had to make it appear at any rate that they were respecting the Foreign Corrupt Practices Act. In fact, on the ground, as nearly as we can make out, it had no impact at all on the behavior of American corporations with respect to bribery. So what had happened, as nearly as we could make out, was that an industry had developed with respect to trying to understand how, in fact, you evaded the Foreign Corrupt Practices Act in international transactions while appearing to, in fact, respect it, and that it had not had an impact on the ability of Americans to do anything internationally. And on the basis of that, I was skeptical of what the impact would be if the Foreign Corrupt Practices Act was actually internationalized. Law is not always the answer to these kinds of problems. What intrigues me about this particular convention, because I've moved away from that area, I've been off the board of Transparency International for about 10 years, but what's impressed me is the realization that passing the law is simply not the answer to the problem. That there have to be a number of different initiatives that are going to be implemented, one of which, a concern of mine, was third-party arm's length assessment of implementation practices. Unless you have third parties who do not have a direct interest in the implementation practices of corporations, to take one example, or governments for that matter, it's very unlikely that the legislation is going to become effective. So I think it's interesting, it certainly is interesting to me, the number of comments and observations that have been made over the last 24 hours with respect to the different initiatives that are now being taken to ensure that the developments that are taking place, certainly the legislation, but other developments, the ethics codes that are being put in place, are actually beginning to make a difference. And now, as nearly as I can make out from the reports that I receive, and I still try to keep track, there hasn't been a significant dent made in the incidence of bribery internationally. I'd be happy to see somebody contradict that, but I haven't seen any evidence that's made a difference, and neither is Transparency International, as nearly as I can make out. Nevertheless, I think the initiatives that are being taken are significant, and the variety of them is extremely important. So I'm looking forward with considerable interest to what our colleagues here on the panel have to say about the various versions of Foreign Corrupt Practices Act and the moves that have been made to make them more effective than they have traditionally been. That having been said, I'm not going to introduce the panelists individually. We want to move quickly to what it is they have to say, but their names are clearly indicated and their bios are set out very briefly in the materials you have. I'm going to leave it to that, and I'm going to ask Ellen if she would launch our discussion. And while she makes her way to the podium, I'll just remind people on the panel that I'm going to observe, as nearly as I can, a fairly strict time limit. We're aiming at 14 minutes for each presentation. Ellen.
Thank you. So as you can see, the title of my paper is Banning Bribes Abroad, U.S. Enforcement of the Foreign Corrupt Practices Act. And in it, I report on a notable pattern of increased and intensive enforcement by the United States of this act, which prohibits bribery in international business transactions. And specifically, the Fcpa prohibits bribes paid abroad, meaning outside the territory of the United States, to foreign public officials, by U.S. persons and by non-U.S. issuers with registered securities in the United States. In other words, this act contains significant aspects of extraterritorial jurisdiction, and that's a theme which is at the center of my current research program in international relations. I'm neither a business expert nor a lawyer. I'm a political scientist. And I'll return to the theme of extraterritorial jurisdiction in the course of my remarks. My focus today on U.S. enforcement of the Foreign Corrupt Practices Act contributes to a burgeoning literature on this subject. In recent years, FCPA enforcement actions in the United States have become the subject of tons of scholarly attention, particularly from international business lawyers, as well as extensive media analysis. And as you can see from the graphs I'm going to show you, in the past 10 years, law reviews and legal journals published almost twice as many articles, more than 1,000, concerning the Foreign Corrupt Practices Act as they did in the previous 26-year period, starting in 1977 when the act was first introduced. And similarly, New York Times articles mentioning the FCPA in the past 10 years are almost equal to the number of articles in the previous 26 years, and almost 6 times the number of articles about the FCPA in the previous 6 years. The New York Times has published an average of 67 articles about the FCPA per year over the past 10 years versus 19 in the previous 6 years. And that's a 250% increase in attention, and that's just from one publication. So apparently, the Foreign Corrupt Practices Act is a hot topic. Now, a good deal of this media and scholarly attention expresses consternation among business-oriented observers that the Justice Department and the Security and Exchange Commissions, the two government agencies responsible for enforcement, have become overzealous in enforcing the FCPA, which has sharply increased and significantly altered the risk calculus of international commercial ventures. And along those lines, as Wes Cragg intimated, an entire industry of FCPA compliance experts, consultants, trainers, lawyers, investigators, and researchers has arisen to meet the concerns of business in the new regulatory environment. So if you're interested in following day-to-day developments in this compliance industry, you can follow blogs like the widely read FCPA blog. You can subscribe to services like those of Trace International. You can read publications like Compliance Week, and you can contract the services of such FCPA compliance firms as Risk Advisory, Mintz Group, FTI Comply, Alex Partners, and many, many others who advertise on the FCPA blog and on Compliance Week. Now, my own research and my talk today is less concerned with offering compliance advice and support to global commercial enterprises than it is with considering the ramifications in world politics, specifically with respect to the global politics of bribery, corruption, and transnational crime, of extraterritorial U.S. enforcement in this area. And my paper grows out of an ongoing research agenda that I've been pursuing into the international regime of anti-corruption, which has emerged since the 1990s and which includes a variety of international treaties, regional organizations, civil society groups like TI and others. And I won't say too much more about this global political context, except to emphasize that corruption, without question, is a primary item on the contemporary agenda of global governance, as well as on the agenda of US foreign policy. And the research that I'm presenting here is motivated by this context. So in the balance of my talk, what I'd like to do is first present some of the data on the FCPA enforcement to demonstrate two significant trends. One is increased, indeed stringent and vigorous enforcement of this act since 2004, which, although having received a ton of attention in the business law literature and in the media, has received practically none by my colleagues in political science and international relations, which is a bit surprising, but which I intend to remedy. And two, the application of increasingly expansive extraterritorial jurisdiction, an issue which in general is the subject of an emerging body of literature and international law across a range of issues, but which also remains neglected in IR, my field, also surprisingly so. And second, I'll discuss some of the implications of these trends and the issues that they raise for the global governance of bribery and corruption. Namely, the recent pattern of Fcpa enforcement affects the global governance of corruption generally, both by promoting anti-corruption enforcement in other jurisdictions, which may be a salutary effect, but also by shaping and constraining the manner in which global anti-corruption enforcement is pursued in general in perhaps somewhat less salutary ways. At this point, I should also note that my paper also considers some alternative explanations that have been proposed in the media to account for the recent trends in Fcpa performance, but because I would run out of time, I'm not going to talk about them now, but I'd be happy to answer questions along those lines later. So, to begin, let's look at some data and trends with respect to US enforcement of the Fcpa in the 21st century. So to begin with, the Department of Justice and the Security and Exchange Commission have pursued an unprecedented number of Fcpa enforcement actions since 2004, dwarfing all enforcement actions from 1977 up to that point, and far outstripping the enforcement of similar rules by other states in other jurisdictions, also outstripping enforcement of other business regulations in the United States. There have been over 100 corporate cases which have yielded record sums of fines and disgorgements of profit totaling more than $5 billion. There have also been prison sentences for individuals and far-reaching consequences for enforcement in other jurisdictions. Now, I'll just say as a side note that there's problematically with this data, the number of enforcement actions one counts varies from source to source due to a lack of consensus over what counts as an enforcement action. There are at least two approaches to identifying Fcpa enforcement data, and I'm adopting what's called the core approach, which collapses multiple charges yielded from large investigations into single data points. So in some respects, these numbers are even lower than other data sets. And the source of this data is from Sherman and Sterling's Fcpa Digest. Anyways, regardless of the variation of the data, it's clear across the board that the number of investigations and actions, as well as punitive measures assessed from that data, enforcement of the Fcpa has been a growing focus of the US government. And here you can see the average corporate fine ranging from a low of $7 million in 2005 to a high of $99 million in 2008, and an overall average fine of $45 million per case. The median is 32. And last year in 2013, the average corporate fine was $85 million. Now, we don't know if this trend is going to continue, but given the number of ongoing investigations, most observers tend to think that the trend of increased enforcement and high fines is likely to continue, at least in the near term. Now, in addition to an increased number of enforcement actions pursued, the Department of Justice has increased its enforcement of the Fcpa specifically against individuals, not just companies. 178 individuals have been charged either civilly or criminally for Fcpa violations, and at least 45 individuals have been criminally sentenced under the Fcpa, either to probation or to prison, far more than in any other jurisdiction enforcing rules against transnational bribery. Fcpa prison sentences vary widely, ranging from 15 months up to 15 years, but the average prison sentence is about 2 years. And this level of enforcement has been a signal to executives and employees at all levels of international businesses that the US government intends to hold them criminally responsible personally, not just their firm, should they be found guilty of Fcpa violations. Now, another aspect of increased FCPA enforcement that is notable has been the prevalence since 2004 of deferred prosecution agreements and non-prosecution agreements in FCPA enforcement actions. These agreements serve to avoid costly trials, and they also secure lucrative fines for the department and the SEC. But above all, they concentrate the extrajudicial enforcement authority of the Department of Justice and the SEC, because the absence of trial judgments precludes the development of case law on which FCPA defenses might otherwise be based. So, in addition to increasing FCPA enforcement efforts through various actions, a hallmark of FCPA enforcement in the past 10 years has also been the increasing jurisdictional expansiveness of FCPA enforcement. And I'm speaking specifically of extraterritorial jurisdiction, which extends the scope and reach of national laws into global regulatory environments and into other sovereign territories. The first time the Justice Department took criminal enforcement action against a foreign issuer for violating the FCPA was in the Statoil case, which the department resolved in 2006. And that case involved illicit payments totaling just over $15 million over an 11-year period by a Norwegian oil and gas company to an Iranian oil ministry official in exchange for oil and gas contracts. To resolve the matter, the Norwegian firm agreed to a $10.5 million criminal penalty and entered into a 3-year deferred prosecution agreement. And at the time, the Justice Department intended this case to, quote, send a clear message today that if a foreign company trades on U.S. exchanges and benefits from U.S. capital markets, it is subject to our laws. The department will not hesitate to enforce the FCPA against foreign-owned companies, just as it does against American companies. Now, to date, approximately 25% of all foreign bribery actions and investigations by the U.S. have involved a company headquartered outside the United States or an individual employed or retained by such a company. Now, I have listed other examples of extraterritorial enforcement, including the most recent Total case, but I'm going to have to shrink my comments to note that one trend within this increasing expansion of jurisdiction is that the Department of Justice tends to rely on a theory of jurisdiction that maintains that very minor acts or pass-through acts, such as emails, which go through U.S. servers, or wire transfers through American correspondent bank accounts, are sufficient to establish jurisdiction, even if the email being sent is being sent from outside the country to a recipient outside the United States, and even if the money being sent through a bank transfer is not knowingly or intentionally routed to the United States and does not remain in the United States for a significant length of time. So, in sum, as part of the SEC and DOJ's firm emphasis on prosecuting FCPA cases, they've also expanded their interpretations of the FCPA's jurisdictional reach, particularly over foreign nationals and companies. So, I think I'm going to have to take a little bit more time because I planned for 20 minutes, but I will be brief. So, the next question is, so what? What are the implications of these enforcement trends? In the first place, it obviously means that any issuer with registered U.S. securities and their employees, whether a U.S. or a non-U.S. person, should be wary of running afoul of the FCPA in this new era of enforcement, and hence the rise of the FCPA enforcement industry. But at the same time, I would suggest that the pattern of enforcement holds deeper implications for the global governance of corruption in at least two ways. So, on On the one hand, U.S. enforcement of the FCPA can be read as a laudable effort by the United States to contribute to the global prohibition regime against transnational bribery and corruption, particularly that associated with the OECD Convention. And research by the political scientists Abe Newman and Sarah Kaczmarek has shown a powerful association between extraterritorial FCPA enforcement actions by U.S. prosecutors and national enforcement of foreign bribery regulations in target countries. They have found that jurisdictions that experienced a U.S. intervention were 20 times more likely to enforce their own national anti-corruption rules than jurisdictions which received no FCPA attention. So in this sense, the FCPA stands as a key pillar of the global anti-corruption regime in which the United States is the leading enforcer. At the same time, the application of the FCPA across borders to persons and circumstances occurring outside the territory of the United States raises important questions concerning the roles and functions of power, legitimacy, justice, cooperation, and efficacy, and national interest in global governance. And as such, it requires further scrutiny. And I'll just mention a couple of the remarks that I had intended to. One critical matter is the fact that the FCPA comprises a very narrow conception of corruption, which is derived from the particularities of the US political context in which the FCPA emerged, and which focuses exclusively on transactional bribery. So ignored in the FCPA and in the global regime are the broader patterns of transnational corruption networks and practices in which bribery transactions are embedded and in which US actors are often complicit. And so the reach of the US legislation shapes and constrains the global regime to a largely limited focus on bribery and on discrete incidents of bribery, which is transactional, which is often modeled as a principal agent problem, and which tends to single out specific actors for corrupt deeds and specific instances of corrupt transactions, rather than tackling the embedded networks and practices in which opportunities for corruption are cultivated both locally and in the global economy writ large. And I think I will just conclude by saying there are many more implications, but finally, a skeptical view of the efficacy of US enforcement is warranted. And one might ask, to what extent are the sanctions being imposed effective at curbing the scale and scope of bribery in international business, to begin with? And also, to what extent are they at all helpful in addressing real problems of corruption affecting people's everyday lives? At the very least, to conclude, US enforcement of the Foreign Corrupt Practices Act may be a case of smoke with no fire. And despite the appearance of vigorous enforcement in the context of the global regime, US enforcement of the FCPA reflects specifically American political imperatives, and it offers the sheen of activity but very little efficacy to curbing corruption on a global scale. Thank you, and thank you for indulging me.
Good morning. So I also prepared a presentation for 20 minutes, and I actually prepared 22 slides for 20 minutes. So now, good luck to us. I need to do this in 14 minutes. So I'm hoping to take us to a little bit of a warmer place, better weather, a little bit of worse corruption indicators, which is Brazil. So let me start with some really good news. Brazil, according to some people who have been analyzing it, has pretty much a good set of laws in place in order to fight corruption. So if you take a look, the efforts to reduce corruption have started in the 1940s with the criminalization of corruption. And then you go through the 50s with crimes against the administration. And in the 90s, the activity there is a lag there. In the 90s, the activity picks up again. And you start seeing a whole bunch of laws being enacted in order to curtail corruption in the country, right? So the activity goes throughout all the 90s, the 2000s. We keep going further with a whole bunch of transparency initiatives, which have been very important. And this all culminates in 2013 with what's now called the anti-corruption law, which is the final touch that was missing in the Brazilian regulatory framework, which is the corporate responsibility for corruption, because before 2013, we were not able to prosecute companies. We could only prosecute the individuals. So this is a major shift that has happened. Now, the problem is that despite the existence of such a robust legal framework, the not so good news is that the indicators have not changed much. So you see a lot of attempts to curtail corruption by passing legislation, but when you look at the corruption indicators, and here is the World Bank governance indicators, they have been pretty stable, right? So you see a lot of legislation being approved, but you don't see a lot of change in the indicators. The same thing with the Corruption Perceptions Index produced by Transparency International, which hasn't changed much regarding Brazil in the last 10 years. I'm just going to make a note here. The drop there in 1992 is when we impeached our first elected president for corruption. So I think everybody there got really hopeful, and then things went downhill again. This is basically where we are at in Brazil. We have a spectrum of laws that's pretty robust, but the indicators have not improved. And the question is why? Why we don't see the corresponding results. And the response has been given by two political scientists, Matthew Taylor and Timothy Power, in a book published in 2011 called Corruption and Democracy in Brazil, where basically they say that once you enact legislation, what you're gonna need in order to make it effective is what they call the web of accountability institutions, which encompass oversight institutions, investigation institutions, and punishment institutions, right? So the legislation is in place, but if nobody's surveilling what the actors are doing, if nobody is, once there is a red flag, investigating further in order to collect evidence and bringing this evidence to a court of law and an institution to impose sanctions, the legislation will be sitting there doing nothing, which is exactly what's happening in Brazil. So what I want to talk about today is the law that was enacted in 2013, the law that created corporate responsibility for corruption in Brazil. And what I want to suggest today to you is exactly what Juan Ronderos suggested in his question in the previous panel, which is, I think there is a lesson here coming from Brazil regarding how to make enforcement of anti-corruption laws more effective. And I think this law is a good example of an interesting, innovative arrangement that could perhaps be copied by other countries. So basically, my presentation, I will talk a little bit about the legislation just to give you a sense of what's covering, but I will reduce that largely in order to focus on what I think is the most interesting part, which is the enforcement portion of it. So let's start with the legislation. So basically, this is the similarities between the Brazilian anti-corruption law enacted in 2013, the US Fcpa, and the UK Bribery Act enacted in 2010. So you can see that they are largely similar in general. Foreign domestic is slightly different because the US is just focused on foreign, Brazil and UK do foreign domestic, but they all cover intermediaries. They all have incentives for companies to have compliance mechanisms. There is a typo there that should be ownership change. The ownership, even if the company changes hands, if something was done wrong before, that will not curtail liability. And leniency has been present with different time frames. The US has been doing it for a much longer time. The UK has just started it, and Brazil has also jumped the bandwagon to have leniency agreements. Now, this is the interesting part, right? The differences are striking, especially regarding the fact that in the middle there of the table, you're going to see that Brazil does not require intent. So basically what the Brazilian law is doing is imposing a strict liability for corruption. If you paid for something and you got a benefit out of it, it doesn't matter whether you had the intention to bribe an official. And this is a pretty significant shift if you compare the Brazilian statute with US and UK. Okay, so I'm half time. So one of the questions you might be raising is, why did Brazil went down this route? And my answer to you will be, in order to address the problems with enforcement, okay? So let me just shift here to the second part of my presentation, which is the enforcement structure, building on Matthew Taylor and Timothy Power's enlightening book. So basically, there are two potential ways in which you can organize this web of accountability institutions, right? One way is you just keep all the institutions operating these three functions very separated, and you try to set up mechanisms for them to coordinate among themselves. And the other way is the second way down here, where you basically aggregate all the functions into one specialized entity. And this has become quite widespread among the international community, with the famous idea of the anti-corruption agency. So Hong Kong was the first to successfully implement this. A whole bunch of countries tried to follow that, some more successfully than others. But the idea here is that a specialized agency that aggregates all these powers could be more effective than a dispersed set of institutions. So what I have been doing in Brazil is I have been analyzing this web of accountability institutions. And what I came up with, this is work that I have done with Lindsay and Carson, and we have a paper out already, is what we call institutional multiplicity, right? So let me just backtrack for a moment. This work was not applicable to the legislation. The new anti-corruption law is just general enforcement of corruption sanctions against public officials, so exactly the demand side that has been raised a few times here at the conference. And the question we are asking was why there has been so little enforcement of sanctions against public officials. The answer is that there is a lot of institutional multiplicity in oversight. There is a lot of institutional multiplicity in investigation. But when you get to punishment, everything is basically ends in the judiciary. And our judiciary is not capable and able to impose sanctions timely. It's a judiciary that's very formalistic, so the requirements of evidence are so burdensome that basically you are going to have a very hard time trying to prove your case successfully. And even if you do, it's going to take such a long time in order for the decision to be enacted that you're going to run against the statute of limitations. So what you end up seeing in Brazil is, there is a lot of increased activity in oversight, increased activity in investigation, and everything stops at the punishment level. So what I want to do in my last 5 minutes is to show how this new legislation tackles that, right? So this new legislation basically doesn't involve criminal sanctions, which would require judicial involvement, and that's we don't have criminal responsibility for companies in Brazil, so that would have been an uphill battle. But it also doesn't rely a lot on civil sanctions. And part of the idea of not relying on civil sanctions is that you're taking out the entire need to go to a court of law. So basically what the legislation is doing is putting everything on the administrative sanctions so that the sanctions can be imposed outside of the judiciary, right? Now, when we're talking about corporate responsibility by domestic companies within Brazil, which I'm calling here domestic corruptions, the system to impose these administrative sanctions is very decentralized. So we go back to that slide where I was talking about institutional multiplicity. Basically, any level of the Brazilian government, any agency can start an administrative process in order to prosecute a company and impose an administrative fine for bribing a public official. Now shift this to foreign corruption, and this is where it gets really interesting. Basically, the legislation is doing exactly the same, meaning taking out the criminal responsibility, not relying on civil responsibility, but also is taking out the internal decentralized, any agency can enforce this, any part of the government can enforce this, and it's centralizing everything into what we call the Controladoria Geral da União. This is a body that was created at the federal government to fight corruption, and they are going to centralize every single administrative prosecution of Brazilian corporations who have bribed foreign officials outside of Brazil, okay? So now what we're dealing with is CGU is centralizing the prosecution, and we're focusing on the administrative sanctions in order to bypass the judiciary again. So why is this so interesting? Because I think Brazil, one, is creating a very, very interesting mechanism to bypass problems of enforcement that we often see in developing countries. We were just having a conversation here about judicial training, right? How do you train the judges? They are not prepared, and then you go down, and the judiciary is not independent. So now, when you look at this, you are basically looking at, oh, okay, so now we need to revise the legislation and then do an entire judicial reform for the entire thing to be effective, right? Well, Brazil came up with potentially a solution where you don't need to engage in such a daunting endeavor in order to make this effective. That's number one. But number two, and that's where I came in as an academic, because of my hypothesis that institutional multiplicity is better for enforcement because you don't have bottlenecks, right? You have multiple pathways in which to pursue. Basically, I think that this new legislation will create the perfect natural experiment, because now we can test whether the domestic corruption is going to be prosecuted more effectively than foreign corruption in Brazil, and that will test largely the widespread claim that has been made among experts in academia that independent judiciaries and autonomous anti-corruption agencies is an effective strategy to fight corruption. It might be, it might not be. I think Brazil could be a good test case. Thank you.
Thank you very much, Mariana. Poonam?
Thank you. So I'm going to skip over a lot of these slides and focus on the two things that I think will be most valuable in terms of the contribution. You've had quite a bit of discussion about theories of foreign corruption and theories of regulating and legislating in relation to foreign corruption. What I'd like to speak about is the Canadian legislation in terms of the Corruption of Foreign Public Officials Act, what the jurisprudence looks like, the very limited jurisprudence, what kind of analysis and critiques I have of the very limited jurisprudence, and then the second contribution in terms of the paper that I'm working on with a colleague, Andrew Nicol, is looking at whistleblower disclosure policies of the largest publicly listed companies on the Toronto Stock Exchange, on the S&P TSX index, and looking at their whistleblower policies and seeing what they have to say about corruption and anti-corruption policies and internal controls that they might have. And I'd like to share those very brief results with you, and then also speak briefly about what companies internally can do to address corruption to the extent that they are serious about it. So let me flip over this slide. Why we care. Of course we care, and we had a chance to talk about it yesterday. Obviously there's short-term benefits to the companies that might receive some preferential treatment, but obviously there's longer-term concerns at a macro level in terms of stability, the primacy of rule of law, and concerns in terms of foreign investment and just kind of an even and level playing field. How can we respond to it? Again, I won't get into these sorts of details. I'll focus in on the legislation. This we've talked about this, and let me turn to Canada. Okay. I saved a lot of time there. Okay. Yes, so I'm going to speak about the statute. So in terms of the Canadian statute, implemented in 1997, and the Act has the effect of extending many aspects of Canada's criminal code prohibitions on corruption in the domestic context to the conduct of individuals and corporations operating in foreign jurisdictions. Now, in response to international recommendations and criticisms that our legislation was not robust or strong enough, the Act was further amended in 2013 to enhance, or appear to enhance, the ability of Canada to prosecute a wider range of activities and impose more stringent sentences. So in 2011, the OECD Working Group on Bribery released quite a critical report on our Canadian legislation and our conservative response in terms of the jurisprudence and the case law and the actual enforcement cases to international corruption. And so some of the recommendations were that the Act apply to both for-profit and not-for-profit entities, and that's been changed as well to limit the ability of companies convicted of an offense under the Act to contract with the government, and then also additional steps to sanction corporations which use off-balance sheet accounts to conceal their corrupt practices. And so in this context, the Canadian Act was amended in 2013. It removed the for-profit basis of the company so that we could broaden the scope of organizations that could be involved. It increased the maximum prison term from 5 years to 14 years, and it also criminalized the falsifying of books and records of a corporation to conceal corporate activity. It also eliminated, interestingly and importantly, that there be a nexus between Canada and the alleged offense before charges can be laid against Canadian citizens or permanent residents or businesses. And it specifically empowered the RCMP to lay charges under the Act. So just a specific point of clarification under the Act. Now, our provisions do mirror the U.S. SEC's original approach to regulating corruption through enhanced disclosure requirements designed to force corporations to disclose the existence and character of all payments that are made through the corporation. And more importantly, the Canadian Act's accounting provisions extend liability for corrupt payments to individuals within a corporation who facilitate or conceal payments that are made by others. And I think in this sense, the legislation attempts to promote greater accountability. but the Act does stop short of providing a more comprehensive regulatory regime which creates the incentives, I think, that are necessary for businesses to internally address and minimize the risk of corruption by agents and employees and through kind of the firm culture. So again, this speaks to some of the earlier commentators in terms of our legislation also being very transaction focused as opposed to trying to look at the system as a whole in terms of the organization or the economy as a whole. So I think that's certainly one of the critiques with the Canadian legislation as well, and we can speak more about it if there are questions. Now, a couple of cases, and there's not very many, but I'd like to highlight them. The first is the Chowdhury case, which spoke to the jurisdictional boundaries of the legislation. People or actions taken wholly outside of Canada are not subject to the purview of the legislation. So the legislation is limited, and the judicial interpretation of the legislation is limiting. And that's the first point I think that is important in terms of the scope of the legislation. In addition to the Ontario Superior Court's decision in Chowdhury, there have been 4 convictions that have been rendered under the Act, including only 1 prison sentence. So these numbers appear to be quite low in comparison to Ellen's statistics from the US. Of course, we have a much shorter history with the legislation, and second, I haven't had a chance to compare the Canadian data, the limited numbers that there are, with the US data, but I'd be interested, of course, in looking at appropriate deflators such as GDP and population to see what the comparisons are in terms of the number of cases. So that's another point. Now, I'm happy to go through the cases in more detail. Each of them are very interesting, but let me just lay out some observations in relation to the cases. I think the current enforcement efforts in relation to the Act show a troubling lack of consistency, both in terms of the magnitude of the sentences that have been issued under the Act and the individuals or the entities that have been prosecuted to date. So most notably in Watts, which I have on this slide, the $25,000 fine appears grossly disproportionate to the fine that was issued in a subsequent case, Nico, where they were fined $8 or $9 million. As well, there seems to be quite a difference in the proportionality. Here you have the fine at $25,000 and the payment that was made at $28,000, so about a 1-to-1 ratio, whereas in this case you have a $9.5 million fine for a $300,000 bribe, which is obviously a much higher sanction. Now, given the difficulty of, and I've written about this in the past, haven't yet written about it in this draft paper, but given the difficulty of enforcement in this area, and given that in all of these cases there was quite a bit of either voluntary disclosure by the company, by new management of the company, for example, or by a competitor, it's very difficult for enforcement officials to detect. So given the low probability of detection, my suggestion, and I've written about this in the past, would be that the fines for egregious cases should be relatively high. Given the low probability of detection, the fine should be higher than what the actual payment was, or what the benefit that the company received. It should be a multiple of that value. Now, 2 other cases that I will speak to, and those are the only 2 other cases that are in this area, relates to the use of criminal sanctions as against individuals involved in the fraudulent activity. So currently, under the Canadian framework, under the Canadian framework, no individuals have been responsible, no individuals have been held responsible where they've been the ones actually providing the funds. The ones who have been held responsible, only one, in Karigar, is the intermediary who assisted the company in bribing the Indian official. So it was the intermediary, the third party, that was hired to make the bribe or make the bribe payment in India, was the one that was prosecuted in Karigar, whereas the official official with the company that made the bribe basically got off in exchange for his testimony. So that I find to be interesting, and then combined with the fact that, and troubling as well, and combined with the fact that in all of these cases, it is the, apart from Karigar, where it was the intermediary and it was an individual, all of these cases, the company itself, the organization is the one that is fined, as opposed to the individual, the senior officer or manager who may have agreed to the fine or have been leading the process. It's the corporation. And I haven't been able to go back to news, public sources or to other sources to determine if initially there was an investigation against the individual, if there was a charge against the individual and the corporation, and the charge against the individual was not pursued in exchange for agreement with the corporation, which I know often happens in other criminal cases. But I think that raises a policy issue about what is the most effective way of moving forward in terms of deterrence in this area. Is it better to convict the corporation, the entity, or is it better to convict the individuals that we might be able to point fingers to? And of course, if we focus on the individuals, case law in other areas of corporate and white-collar crime certainly suggests that it's often not the senior officers or the board members that end up with the convictions. It's the middle and the lower level employees. So that, of course, raises another concern. So I have very little case law to share with you from the Canadian context because, one, because of the shorter history, but two, I think there are concerns that there aren't sufficient resources or attention being paid to this area by law enforcement. And then, of course, as I mentioned, all of the cases came about through competitors raising issues, whistleblowing in some sense, or through voluntary disclosures made by the companies when something untoward was found. Let me now briefly just turn to my review with Andrew Nicol of Canada's kind of largest, most respected companies, and we looked at their 2013 disclosure that's available publicly, and we looked to see if they had a whistleblowing policy. And so we looked to see whether they disclosed their whistleblowing policy in their public documents. Now, in some form or another, all of these large Canadian publicly listed companies disclosed that they had a whistleblowing policy. Now, did they have in my opinion, did they have kind of the most robust, best whistleblowing policy that they could to encourage instances of wrongdoing or corruption specific to this conference? No, I don't think so. And why do I say that? Well, not all hotline numbers, so to the extent that there's a whistleblowing hotline, they weren't publicly disclosed. That may not be terribly significant as long as they're disclosed to the employees. It wasn't disclosed in the public disclosure documents. Second, and this troubles me quite a bit, is that there wasn't an independent whistleblowing hotline, in the sense that the whistleblower, the whistleblowing hotline, the other person that picks up the phone when you call to say you're concerned about something at the company that you work at, could be your boss. And I think to be most effective, and many companies do have this, is to have an independent third-party monitor that actually responds to whistleblowing allegations, to concerns about what someone at an organization has seen. So there's very limited use of third-party monitors, and I think that is indeed troubling. And then the third piece that's relevant for what we're discussing today is that certainly there was very little mention. Most issuers failed to mention corruption as something to be disclosed and something to be concerned about. Now, all of them mentioned accounting irregularities, but and certainly corruption can fall into accounting irregularities. But I think specifically highlighting corruption as a part of a institutional, organizational program is important if you want to actually address it head on. So So I think there's a lot that companies internally can do to address corruption if they are indeed serious. And then I think there's a lot on the front end in terms of accounting procedures and procurement policies. There's a lot in terms of the processing of contracts and who is responsible for signing off, as well as a lot that the board of directors and the audit committee can do to ensure that there are internal controls and procedures in place. And then on the external front, I do believe that regulators can do a lot more. I think there's a role for the criminal system, but I think there's a role that regulators can play as well, which ties in with some of Maria's comments, particularly securities regulators and financial institution regulators in terms of providing best practices and guidance to companies in terms of what might be appropriate to institute within their organizations. So why don't I end here, and I would love to take comments and questions later. Thank you.
Thank you very much. Michelle Ratpan. Expertise here at all.
Is there somewhere I could put a thumb drive? One? Thank you. It's not in that list.
We'll figure it out.
Never thought of that. That should have been done before. See what's happening is we've actually, we will run out of time. I don't know what time do you want us to quit? 12:45. Yeah. It's very easy.
Right. Can everybody hear me? Yes? Wonderful. Okay, so as most of you already know, I work for the World Bank's Integrity Vice Presidency, and I'm here to talk to you today about the process, our investigations, and a little bit of the sanction system. And these slides are going to move pretty quickly, and so I hope you enjoy this presentation. It's quite animated and fun, so I do hope you'll enjoy it. So the World Bank, this logo is just to suggest that I work at the World Bank. Also, just a little disclaimer, any of the views that are expressed today are my views, not those of the World Bank. The World Bank, I think, in some ways can be summed up in the next slide, which is this slum in India. I actually did an investigation at one point in Mumbai. I don't think I saw this slum, but many like it, and it sort of gives the message that, you know, the World Bank is about development and it's about poverty reduction. And this is the goal that we have right now, to end extreme poverty and to increase shared prosperity by 2030. It's a lofty goal, but it's attainable. So why does the World Bank care about fraud and corruption? This is the fundamental question of the group that I work in. It's my sort of purpose in terms of the job that I do. And the answer is quite simple, because fraud and corruption harm development. And that's part of what we've been talking about in this conference yesterday and today. Whether you're talking about fraud and corruption harming development or fraud and corruption harming generally, we can all agree, I think, that there's a harm involved. So INT, that's the unit that I work in. These are just a few facts about INT. It was founded in 1999. Its mandate stems from its Articles of Agreement, and the most important thing in that mandate is that the funds should be used for their intended purposes. INT is an independent body within the World Bank, and it has about 90 staff and with global coverage. So if you can imagine, there's 90 to 100 people whose role is to cover the entire world looking for these, investigating into sanctionable practices. The way we do that, which is what I'm going to talk about a little bit more in this presentation, is looking at documents, conducting audits, interviews, and site visits. So it's very hands-on, and we're very busy. So what we do, this is in a nutshell, the slide kind of describes everything that we do in that unit. Investigations, there are really two forms of investigations. The type of investigation that I'm a part of as a lawyer in INT is external investigations. That's when we look at allegations of one of the 5 sanctionable practices, which include corruption, collusion, coercion, obstruction, and fraud, and we conduct an investigation. Those investigations will be of companies or individuals who have bid on a World Bank project. Internal investigations, it's a bit of a separate unit within INT, and they will conduct investigations into allegations involving bank staff members, people who are working for the bank. Litigation. The litigation process involves, I would say it's like a 2-tiered system. One tier is that INT creates a document, it's the equivalent of an indictment or a factum, and sends it to our Office of Suspension and Debarment. If it passes through the Office of Suspension and Debarment on a standard of more likely than not, then it will proceed to our Sanctions Board, which is an internal board of judges that could potentially debar the entity if they are found guilty of a sanctionable practice. We also have the ability to refer cases to relevant national authorities, which I'm going to speak a little bit more about in another slide because I think it's very relevant to many of the subjects that we've talked about here. Prevention, so our unit also provides training, advice, research assistance to prevent corrupt acts. And integrity compliance. Many of you know about this if you've come about on the side of a company who's actually been found to have engaged in corrupt practices. We assist them with compliance programs in order to ensure that that doesn't happen again. How we do it. In the times that I've made this presentation and not included this slide, I've been asked where did the complaints come from. So I think that this is a very good graph to sort of break it down. Most of our complaints come from World Bank staff members. The next part comes from non-bank staff members, and then anonymous complaints. That can be, potentially people who see corruption or fraud in projects and want to do something about it on the ground. They may give us a complaint. So why we care. The next few slides are going to talk about why we care about fraud and corruption and the sanctionable practices. Someone yesterday asked a question about what is fraud, how does it relate to corruption, why does it matter? So in my view, often, we'll investigate a case and we will find a fraudulent act there, which just so you know the definition of a fraud for us, it's an act or omission which includes a misrepresentation that knowingly or recklessly misleads or attempts to mislead a party to obtain a financial or other benefit or avoid an obligation. So sometimes we will find under an investigation, we will find an act of fraud. There may be a corrupt act underlying that, but it's potentially that we cannot find that act or there's not enough evidence. So I give you an example of a fraud. This is a true story of a hot spring spa and ecotourism center. These are the plans for the center on the left. It was supposed to be a beautiful pool with foliage around and an upscale resort. After 50% of the funds were dispersed, with 30 days left to completion, this is what it looked like. So that's to give you an idea, was there a corrupt act here? I mean, where did the money go? This is the ecotourism spa. I don't think it's a place that any of you would want to go for a holiday, but that's what it looked like 30 days from completion. Juan showed you this baby warmer slide. So this slide, it kind of puts the message about development and about fraud and why we care so much about it, because this was actually a baby warmer that did go to a hospital. This was supposed to be new. This was supposed to be fully paid for. And this is what it looked like. Not only is it rusty and obviously not under the conditions that you would want to put your child in, but also if you were to plug it into the wall, it was very likely that it would electrocute the child within it. Why we care about fraud. This is close to my interest very much because it deals with health. And I think, corruption when it happens in health can be something that is very scary. This was a case, it's a redacted report, where medications were provided through a bank-funded project to treat leishmaniasis, and it's a disease that comes from a bug bite. and the ingredients in the capsules weren't active. So people were getting these drugs to treat the condition, and they weren't working. I've included Ebola and fraud as the next slide. This is not a case that we have right now in INT, but it's just to give you an idea of what could happen, a possibility out there. It's something that I recently wrote about, and I think you'll find it interesting. Counterfeit medications. This is something we're worried about. So let's look at the current Ebola outbreak because it's in the news right now. It's in West Africa. We know that there's been over 4,000 deaths. There are some antivirals and drugs that are available that are being researched right now, but there's no cure, there's no vaccine. So at this point, what we know is that the only way to treat Ebola is through managing the symptoms. 30% of the African market right now has fraudulent pharmaceuticals. For malaria medications, it's a huge, huge problem. When you look at what's required to treat Ebola, it's antibiotics, painkillers, cough medicines. Those are the things that manage the symptoms for Ebola. Those are also the medications that the World Health Organization has said are vulnerable to counterfeit. So you can imagine a situation that a person gets into. They need the treatment for Ebola. Any of those medications that don't have active ingredients reduces their chances to survive. So why we care? This is on the corruption side because we're talking a lot about corruption. This is a true project that we had. It was a road rehabilitation resurfacing project. That's what it looked like 1 year after completion. There's no resurfacing, it's just a dirt road. It likely looked that way before the funds were dispersed. We were able to trace the fact that the money actually went to the project manager so he could make a mansion for himself. So that was a successful investigation, but it shows you bribes are happening, they are going into the pockets of officials, it's a problem. We also talked, we've been talking about SNC-Lavalin, we've been talking about construction, and someone made a really interesting point yesterday about that the construction industry is really vulnerable to corruption. This is a case where these materials that were used to build this establishment were faulty, didn't hold up, and in fact fell down. And that's a danger to society. You know, it's a very serious thing if the hospital, if the school that you are in collapses due to the fact that the materials that were used to build the infrastructure weren't high quality goods as they were supposed to be during the contract process. How we do it. I love this slide because this is exactly how we do it. We go and investigate companies, we do audits, and this is the sort of thing we get. We get piles of documents that we sift through. Sometimes you're fortunate, you'll get payments, invoices. This actually happened. One time we did an investigation and someone made a receipt for a bribe payment. And we were able to use that in one of our cases. Obviously, it rarely happens that someone will pay a bribe and request a receipt. But in this circumstance, this man was so sick and tired of paying bribes that he actually started to request receipts for his bribes. And he gave it to us. We do inspections, on-site inspections. This was a case where the roads were so horrible that the truck drivers in India refused to drive on the roads anymore. They actually went on strike because the potholes were so big. This is one of our investigators who is actually measuring the size of the pothole there. We also do site visits. This was the site visit that was done by one of our investigators to the ecotourism to find out that it wasn't there. So this is just a chart of our process. Happy to discuss this later if you want, but it starts in an investigative stage. We do these document collections. We do the site visit. The investigative report will go to the president for him to sign off on. After that, there's possibility of misprocurement, a review of the contract. What I said that I want to talk about a little bit, which I think you will find very interesting, is the referral report stage. We can refer a matter to a government, and that's what happened in the Padma Bridge case. The World Bank referred the allegations of bribing of public officials to the Bangladesh authorities and said, do something about this. We'd like it to stop, so we ask you to do something about it. Remove these officials. We can do that in our referral reports. We can ask that officials that we believe or we've shown have engaged in corrupt acts be removed from office. The referrals also play another role because when we refer a matter to national authorities, they can engage in their own domestic prosecution should they choose to. Again, SNC-Lavalin is a great case and I think a great gold star for Canada because the matter was referred and the Canadian authorities picked it up and are now engaging in their own national prosecution of the matter. We can release redacted reports, and basically my main work is to write statements of accusations and evidence. So as I said before, it's a type of indictment. You write to basically our Office of Suspension and Debarment, and you make your case, and it goes through the sanction system. This can lead to debarment, which we've talked about here too, which is a pretty powerful tool. It means that a company can be debarred from all World Bank projects for several years. So the legal framework, I'm not going to go through this slide because it'll take too long, but it just outlines how the World Bank works and the relationships to others in terms of the legal framework. The possible sanctions, as I said, debarment, who we can sanction, firms, NGOs, individuals, who we cannot sanction, governments, government officials, World Bank staff. Okay, sanctions. I put this as like exclamation point just to show that they show up on our website. It creates a serious deterrent effect. We have heard that when our sanctions go up on websites, other companies will look at the entity that is involved or that is debarred and will not do business with them. They also go out in the media. Again, another serves the purposes of punishment and deterrence. Cross-debarment. This is very interesting and exciting. It's an agreement with 5 multinational development banks that if we, the World Bank, debars an entity for 1 year plus 1 day, those development banks will cross-debar them as well. So the company or the individual will not be able to do business with those banks. That is the end. Thank you very much. Happy to receive questions.
All right. I have to have my pen in hand. Okay, so as you can probably all have figured out, this panel has been about remedies to try to address some of the problems that we've been discussing over the last day and a half. And so far, they've all been quite pragmatic. I am now going to be talking about something that's very idealistic, and so I might cut it short. But in general, the issue that I am thinking about a lot is how to structure regulation so that the regulation itself might have an effect within firms with respect to firm culture. The name of this conference is Taming Public and Private Corruption, and what I'm looking at is private corruption. Corruption within financial institutions, specifically banks, that are too big to fail. Now, the context is that after the financial crisis, the too big to fail banks in the United States, which is my focus, are bigger than they were before the financial crisis. There's some statistics here, but just looking at the first one, Bank of America has assets of 16% of the US GDP. And you see these statistics for the other large banks. No one expects that the orderly liquidation authority of Dodd-Frank would actually ever be used with respect to any of these too big to fail banks. What is the implication of that? The implication is that the people operating within those banks recognize that the government won't let them fail. So if anything, they are more risk-preferring now than before the financial crisis, which has been the perspective of officials within the U.S. government and congressional oversight committees. Now, the other point that I would emphasize is that there are credit distortions as a result of that, because the credit rating agencies also recognize that these are too big to fail. So the moral hazard is presumably worse. Now, what is the specific problem of corrupt finance? We have seen an almost, it seems, unending stream of prosecutions and investigations of people within these large, too big to fail banks, not only U.S. banks. And I just have a couple here. The first one that got a lot of attention was the Libor manipulation, London Interbank overnight offered rate. This is a rate that is based on what banks say they are willing to lend and what banks say they have borrowed at overnight. And it is a key rate that a lot of credit relationships work off of. 16 global banks have settled or are being investigated for manipulating that rate. Hsbc settled charges of money laundering. JP Morgan is interesting. It has so far settled mortgage manipulation and also part of the Libor manipulation. So it's paid so far $23 billion. Just this week, it set aside $5.9 billion for potential settlement of a large group of banks that are now being investigated for manipulating the currency exchange markets. Bank of America also settled this week, $400 million, again, currency exchange manipulation. Last, but certainly in the context of this conference, not least, is this problem with tax havens. There are estimates that between $21 trillion and $31 trillion are stashed away in global tax havens. Moreover, the International Bar Association last year had a task force on illicit financial flows, poverty, and human rights. Very interesting report. And in that report, it summarized data from other sources suggesting that developing countries have lost $5.86 trillion between 2001 and 2010 from these illicit financial flows. And very important to note that 80% of these illicit financial flows were corporate transfer price mispricing. Right? Now, corporate transfer prices are the prices that subsidiaries within a global company charge each other for goods and services. It is important, I think, for us to recognize that when we think of corruption and you think of illicit financial flows and money being stashed away in problematic tax havens, I know I have always thought in terms of the kinds of development money that we've talked about here that is going to officials and getting into their Swiss bank account. But 80% of it is global companies taking advantage and misadvantage of global transfer pricing, right? So we are not only talking about corrupt officials in foreign countries, we are also talking about corrupt companies that are located and whose home are in Canada and the United States and in Europe. I think that's an important context. Okay, now having put all of that context, I probably have only about another 7 minutes. Okay, so I'm going to go very quickly here. What does this, the too big to fail creates a moral hazard, as I've talked about. What else does it create? A very interesting book. Karen Ho is an anthropologist, and she was hired by a Wall Street firm from her PhD in anthropology at Princeton, and then was, quote, liquidated, let go. But before she was liquidated, she met many, many other people in the investment bank where she worked, so she has a lot of inside sources. And has written an extremely interesting book, an ethnography of Wall Street. And what you find there is enormous insecurity, employment insecurity, right? She has quote after quote after quote of people who say, look, if the company decides they don't want to be in this business tomorrow, they don't want this desk, right? They're no longer trading in this financial instrument. 25, 30 people lose their job the next day, 50 people. And it's a very public loss of a job, right? A flotilla of human resources personnel walk onto the trading floor with a white box and tap people on the shoulder and say, you know, put your stuff in the box and walk out. Everyone sees it. So there's a real signal there that you might be next. And yet, you're taking these big risks, you know, billion-dollar risks on behalf of your company. You might lose your job tomorrow, but if you do things well and negotiate all of this, there's huge outside financial reward. So from a psychological theory, I do work with an organizational psychologist, Deborah Rupp, as well as an anthropologist and law professor, John Conley. But from a psychological perspective, what this does is exacerbates people's self-interest and their instrumental motives, their need for control, and undermines the other motives that we know people have, which are the relational motives, the need to have good relationships with your colleagues and your family and your friends, and any sort of moral motives that we all have, right? That to care that we are living a life that matters. So we have written about this in this paper here. And when I say this, we've written about the idea that maybe different kinds of regulation can help to bring back into the equation some of the relational and moral motives. Even in, and this is the idealistic part, even in these sort of horrifyingly insecure and yet, you know, hugely financially rewarding cultures. Now, one of the ways that we've suggested regulation could have this effect is by looking at what we do see in soft law regulation. Right? We heard yesterday about the idea that when you're trying to fund a project in the world, what you need at the base of your triangle of finance, we heard this from Michael Robinson, was you need one of the international financial institutions, the World Bank or the IFC or one of the development banks. The reason we heard was because those IFIs have done a pretty serious environmental and social evaluation of the project. So if they say it's a useful project, then you can get private money to pile on. Well, the people in the private money, the global banks, because they are already effectively having to use the standards from the IFIs, engaged with them in developing something called the Equator Principles. And it's basically taking the standards from the IFC, which is the private lending arm of the World Bank, and using those same standards to evaluate the social and environmental risks of their own projects. And I'm going to go very quickly through all of this. We think that engaging in this kind of initiative, this kind of co-regulation, where you need to evaluate the social effects of actions, you need to evaluate the environmental effects, the human effects, could very well help in reinserting the relational and moral thinking. It's not at all, I would never say that it's a complete solution. I think that, you know, to address problematic culture and too big to fail banks, we need structural solutions, we need changes in accounting, and so forth and so on. But this could have something of an effect. And I'm going to go really fast through almost all of this. I've already mentioned all of this. So what do we think? And this reminds me of the review mechanisms that you were talking about, John, this morning. right? What you have are the Equator banks, the private institutions, being part of a learning community, being part of a discussion. Now, in part, it's not just that they become part of this learning community and discussing environmental issues or social issues. There's some real sort of hardcore risk mitigation that goes on by using the Equator Principles and the standards of the IFIs. For one thing, when you're doing project finance, in general, the banks are only repaid if the project is successful. So if people start to, start to cut your oil and gas pipeline so you're no longer delivering any oil and gas, the project is not going to be successful. So the structure of project finance is requiring the companies to sort of internalize risk that other kinds of finance treat as external. Right? But we also think that we've also seen evidence that once the credit committees within the banks are starting to consider these kinds of aspects in their decisions about project finance, then they start to use them in some cases to also include social environmental risk in other of their business, such as their underwriting of stock and bond issuance. All right, whoops. Oh, see, I didn't have to go quite that fast. I have another 30 seconds. What I wanted to just emphasize here is the last 2 points. With the Equator Principles, what we essentially have is co-regulation, right? You have a public entity, the IFIs, the World Bank, and the IFC creating the standards. And then you have private entities using those same essentially publicly developed standards. We see some other instances of this that we are in the process of studying now. The Australia Securities and Investment Commission, which is engaged in co-regulation with professional organizations in 13 different market areas. And then the Dutch National Bank, they've been doing something amazing to me. They have hired social psychologists. They have 8 social psychologists on their staff, and they have for the last 3 years. And the social psychologists observe all of the board meetings. They observe the CEOs in their big decisions. They do evaluations of the culture. So it could well be that these are models that we should be thinking about with respect to the cultures within these financial institutions and raising corruption to a higher level of priority within their thinking, right, as one of the social issues that needs really to be evaluated, standards developed, and addressed. Thank you.
Thank you very much. Well, with the permission of the organizers, we're going to run until 1 o'clock. That's okay? And one of them is on my right, so I guess we're okay, are we? So, questions?
it's on now. Yeah, thank you. Thank you, Francois. I think that's a fascinating question because I think part of the problem I was talking about in terms of judicial enforcement, it is connected probably with civil law countries, right? So you do have the formalism, you do have excessive procedures, and you do have lower levels of discretion for judges in civil law systems. They're famously described as the mouth of the law, right? They're just there to repeat what the law says, not to create new law, right? So the divide between common law system and civil law system has always been marked by this very, very different, at least from a descriptive perspective, not in reality might not be so different, of the actual role of judges, right? So it might be the case that what I'm suggesting here is a model for developing countries with civil law systems and not a model for developing countries with common law systems. But the point is exactly what you're talking about, which is what Brazil has done is created an administrative process that happens within the executive branch. It looks very much like a judicial process. So you have the accusation, you have the gathering of evidence, you have rules of procedures that you need to comply, you need to invite the accused party to come and defend him or herself. You have a process before a sanction is imposed. The difference is just that the sanction is imposed by an executive body, and it's considered an administrative sanction, right?
And it applies both to the private person or the private body paying the bribe, even if it's a private body, and the official receiving.
Yeah, so okay. Exactly. So that's what this legislation, that's the innovation of this legislation. It has empowered CGU, that body, to impose these fines, in addition to a number of other measures, which include publicizing the name of the company, which I think goes back to Michelle's point, which is the idea is other companies will look at the company that has been sanctioned and will say, we don't want to do business with you because you're in trouble. And there is the debarment process as well, which is also an administrative process. But the entire idea here is just that you're not going to depend on judicial action in order to...
So it remains on the books criminally, right? You could go the criminal route. It's just
you could not. The Brazilian constitution does not allow for criminal sanctioning of corporations. It's forbidden.
Oh, that's interesting. But an individual...
Except for environmental damage.
But in terms of individuals, you could criminally prosecute, presumably. Because otherwise, the Brazilian government is saying, we've ratified the convention, and yet we're violating it blatantly.
No, for sure. I mean,
okay.
So there are two levels of the conversation here, right? So the individual sanctioning is still there, and the criminal sanctioning of the individuals is still in place, and everything remains as it was before. And we could have perhaps a conversation about, I think, what you suggested, and might tie back to Cynthia's presentation, about the signaling of criminal sanction, right? You may not need to enforce it, but just the fact that you stated this is a criminal violation enhances the weight that something has in society. So we could have a conversation about that. The problem in the specific case of Brazil was that except for environmental damage, corporations cannot be criminally sanctioned. So that was a no-no, and unless you wanted to engage within the potential constitutional amendment, which would be an uphill battle, that was not in the picture. So that was cut out as a possibility before. Then the people drafting this legislation, and my co-author in the paper is actually one of the people who was involved in the drafting of the legislation, they basically had to make a choice, right? And the choice was, okay, so are we going to focus this legislation on the civil sanctionings? A lot of my work on line development fights against blueprints, right? Do not do legal transplant. Do not pick a legislation from one place and plug into another place, because that's recipe for disaster, right? So I don't think I would be suggesting for other countries to just copy and paste what Brazil has done. What I think it could be learned as a lesson here in Brazil is just the question of what kind of alternative sanctions could you find in your system if you're finding these roadblocks. And the overarching concept is institutional multiplicity, right? If something is not working, you create alternative pathways, not necessarily closing the previous ones, but you just create these alternative pathways in order to increase the chances that some kind of sanction will be imposed. I think that's more the thrust of my remarks.
Good. Thank you very much. Yes.
Great presentations. I had questions pretty much for everyone, but I'm going to reduce them to just 3. First to Ellen, what are your thoughts about the industry around the Fcpa, and if you have given any thought about that, like compliance monitors, compliance specialists within corporations, and the lawyers and investigators and all of that? You were mentioning part of it when you were saying the Fcpa blog has all these ads. What of this is hype? Also, in relation between enforcement and the amount of media, how much of this is hype as opposed to reality? To Mariana, I was going to ask you, what are your, if there has anything been written or said about the potential issues of due process with the strict liability, and if there would be any contradiction with the Inter-American Convention of Human Rights, and what would be the issues there? And finally, to Michelle, if you could talk about a little bit more about the collaboration between the World Bank and government agencies that are conducting criminal investigations or other type of investigations, given that the World Bank does administrative investigations and has privileges and immunities, how they intersect, and how can you transplant evidence from one process to another, or vice versa, without violating the rights of people?
I'm going to ask each of you to be very brief because we have other questions as well. So, Ellen.
Thanks for the question. So what do I think about the compliance industry I referenced? Well, I don't know if the question is really whether it's hype versus reality. I think these are very real business dynamics. I think people are making money offering compliance services. And at least one observer has referred to something called an anti-bribery complex, which suggests that to some degree what I have called the compliance industry is itself driving investigations and enforcements in the government. And we see time and time again lawyers from the Department of Justice who have expertise in prosecuting Fcpa cases leaving their positions to go then into private practice in very lucrative areas, defending firms against Foreign Corrupt Practices Act actions. So there's sort of this self-reinforcing cycle of prosecutions and then services being sold to defend against the prosecutions. That's kind of like a fishbowl action that doesn't have very much to do with the global governance of corruption.
Good. Thank you. Mariana?
I can go? Okay. Very short. Not that I know of, but just to separate here, the strict liabilities is for companies. If you're going to criminally prosecute a person, that the full-blown criminal process code applies, right? So just to separate those two, and the company is not criminally liable. So again, it's so I'm not aware of anybody who has raised this concern, but I think it would be hard to raise this concern given these limitations.
And Michelle.
Hello? No? It's not on? Hi. Hello? Yeah. There's a very long answer to that question, so I'll just try to answer by saying that collaboration is often done on a case-by-case basis. In my experience, we can collaborate either with an organization like OLAF and do investigations in tandem with them. We can collaborate through memorandums of understanding, but it's going to be done differently in different circumstances and based on like the laws of the country and how the World Bank functions administratively. But I can tell you that in my experience, for instance, with collaborating with OLAF, when we conduct investigations, we're able to do those, and we just have to be careful to follow our procedure when we're conducting them and make sure to respect their procedure and work in that way. But it's very possible, and it's definitely a growing area.
Good. Thank you very much. Stepan.
Many of these staffers were in, creating paper trails of their misconduct, and it was like shooting fish in a barrel in the early days. And I'm wondering whether World Bank staff have become more sophisticated in covering their tracks and that sort of thing. Has there been a change in behavior to become more sophisticated in corrupt practices? I don't want to put you in an uncomfortable position, but I'm just interested whether that story could still be told today. And for Cynthia, the psychosocial perspective on regulation is really valuable. And one thing that I think is important, you have the bullet point that on the slide that's still up there about the importance of not having firm self-interest at cross currents with regulation. Now, sometimes, these co-regulatory approaches work best when there is a genuine alignment between the self-interest of the firm and the public interest, but it's not always the case. Sometimes regulation has to be at cross purposes with the self-interest. And I'm just wondering whether you see corruption as one of those situations where the interests can be aligned and co-regulation can work, or
so thank you for your question. I've heard wonderful things about Glenn Ware. I've not worked with him myself. And I'm going to dodge your question by saying that I do not work on internal investigations. And so whether or not individuals working in the bank have become more sophisticated, I mean, I wouldn't know the answer to that. And even, I wouldn't want to guess whether they are or not. But as I mentioned in my presentation, we do conduct internal investigations. It is part of our purview, and there are cases, there have been cases of staff members who are soliciting bribes or involved in some kind of corrupt scheme. So it is part of the mandate, not my personal mandate, though.
Cynthia.
Yes. Very good point. I do think you're right that in some cases you could see some of the Libor manipulation and the currency exchange manipulation as situations where the relational interests between people within the banks were too strong, right, in a way that was not at all productive. So nothing that I said should be taken as this is the only way to affect the cultures. Right? I think that we need structural reform. The banks that are too big to fail are too big to be, right? They need to be broken up. And in fact, Switzerland is in a good process of doing that. Switzerland is in a good process of also reinstituting big separations between commercial banks that do retail and commercial lending and investment banking. Right, so, and also that we might need accounting reform. So, yeah, soft law also has to exist in the shadow of hard law. Yeah, agreed.
Thank you very much. One last question.
Yeah, just because I happened to be at the OECD back in the 1990s when they did both the hardcore cartel recommendation for antitrust lawyers and the bribery convention. What I've observed, though, is that if you take a look at those two things, one that came out in 1997 and one that came out in 1998, there's been so much more enforcement on the cartel side. And the concerns about extraterritoriality that used to animate places like this have largely gone away in the competition world, because there's a lot more cooperation among enforcement officials and a lot more enforcement by other foreign jurisdictions other than the United States. And I contrast that with this foreign corrupt practice area. When I listened to your, I think Professor, sorry, I can't get your last name, your comments, it struck me as, you know, people at the time of both of these things were complaining, well, you know, these are the Americans going on about cartels or all these other anti-competitive practices. Why are these Americans going on about cartels? Well, it was open to everyone else to go about other anti-competitive issues, but no one was doing anything. And I feel that when I listen to that kind of criticism of the American Fcpa prosecution, both in terms of why bribery and why extraterritoriality, well, why? Because you're not enforcing your laws. And two, why bribery? If you want to do something else, go at it. But I don't hear people doing it. And if I could just ask one question to Michelle Rampal, Michelle, sorry, I might have your last name wrong as well. One thought about your presentation. Now, it seemed to me we have this Canadian company that was debarred, you might have mentioned it, in the World Bank proceeding, I think Lavalin or a subsidiary of it.
SNC Lavalin.
Right. So what I have trouble with that one is I still see the Government of Canada awarding contracts to it. Now, I know that you didn't debar them for Government of Canada work, but how do we reconcile that? How do we reconcile this Canadian company that's on a list, that's debarred, it's done something wrong, but the generous Government of Canada continues to do a lot of work with them? Is there some tension there?
I'm not sure I understood the question.
I guess what I'm saying is when you have a company that if you think that their conduct is so egregious, not you being the World Bank, and they're on a list, they're debarred, but the Government of Canada continues to contract with them. Isn't that like a tension there in the system? Maybe it's too playful.
I'm going to do something very unusual, and I'm going to ask Juan to come up and answer the question, because maybe he has a better answer. Yeah.
Because I'm part of the multilateral development banks that have sanctioned SNC Lavalin as part of the cross-debarment agreement. The debarment process is one by which we as multilateral development banks decide not to do business with someone. And basically what we're saying is we're not going to allow our funds to be used to be funding any contract or any operation in which you would be involved. So that's the nature of our debarment. And that is the reason for it. We cannot, for instance, say to a government on one of the countries that we serve that they cannot hire SNC Lavalin with their own funds. They can do it. So I think that the debarment that we do has to be taken into the context of what it really is. It's an administrative sanction that it basically sends the message, we don't want to do business with you, but anyone else can do business with you. It's up to the Canadian government or any other government for that matter to make a decision as to whether or not they want to do it.
Very good. Thank you very much. I think it leaves it to me now to thank the panel for a series of very interesting presentations. Thank you.